Welcome to the Retzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. I'm Erica Adler, shareholder and leader of the healthcare practice at Retzel and Andrus. Today, I'm joined by Scott Brown, who's a shareholder and an intellectual property attorney at Retzel and Andrus. And we're going to be talking about something we've never talked about before, but which is a question that actually gets asked quite often, which is, what are terms of use? When do you need them? What do they include? And what am I even talking about? Which is, I think, probably what some of you might be asking. So I'm going to turn things over to Scott, and he's going to explain to us what we mean when we talk about terms of use and how that might also be accompanied by a privacy policy, which is something different than our traditional HIPAA topic that we've covered before. So Scott, thanks for joining me.
Thanks for having me.
Let's start by having you describe what is terms of use? What does it mean? When do you need it?
Great. Yeah, so I typically do lump terms of use and privacy policy together. They go hand in hand. If you have one, you probably always need the other, but they are different. So these are most often used for when you think of, having a website or a mobile app. They used to be very different, but now people tend to kind of lump them all together. When you've got a website or a mobile app, you need to have a terms of use and privacy policy to support the app and the website in terms of your protection and what you're doing with users' information. So the terms of use is basically the contract between you and your user or your customers to say the stuff on our website belongs to us. You're able to use it because we're licensing it to you. And we disclaim everything on our website for the most part. It's as is. If you get information on here, some health information on here, we don't guarantee anything, any accuracy. It's not medical advice. It's just for your use as is. We're not going to be liable for anything. So it protects you, both protecting the content of your website and protecting yourself from potential liabilities that someone could try to claim from their use of the website or the mobile app if you have one. So the privacy policy is the other side of this. And this is actually your promise to your users about what you'll do with the information they share with you. And so it's not as much a contract, it's more of a promise. Similar concepts, but it's more so telling users what you're going to do. So there are different laws throughout the country and actually the world that affect this. And so the goal of a privacy policy is to comply with the applicable laws. In the EU, they have the GDPR, which is much more strict than any laws we have in the United States on this. So in the US, we basically follow California law for the most part, which is interesting because they have the most forward-looking privacy protections. So if you're in the US, somebody from California may come to your website. That's what you have to comply with. So the biggest thing is what you'll do with your users' information. So the privacy policy is going to say how you collect it, whether it's just if there's a registration aspect of your website, they're going to give you the name, address, email address, any other kind of communication they post on the website, if that's possible. And then you actually tell your users, we will use your information for the following. And almost always you're going to say things like analytics to view what's happening with your website. And then kind of the more out there ones would be if you're going to advertise directly on the website, if you collect information from users and you transfer it to other parties, whether you sell it or not, if you're doing those things, you need to disclose it. And a lot of times when I talk to clients, when they first get started with something, they may think, oh, I'm never going to do that. But you may do it someday. There's a lot of value in data. And so you want your privacy policy to give you some leeway to do the things you need to do to make your business and your website function properly. And one of the biggest risks I see with privacy policies is that people go and just grab them from someone else, put them on their website. What you really need is one tailored to what you're doing specifically. And especially if you are collecting, you have a registration process on your website, if you're collecting a bunch of personal information from people. But also, if you're using a third-party vendor to do all this stuff, you might want to actually check their privacy policy to see what they're doing with your users' information as well. So it's really important to get these things accurate, and they're honestly not that hard. Lawyers that do this work have starting forms to start from, and we just figure out what are the specific things you're doing and how can we best protect you in those documents. And our goal generally then is to draft them once and then try not to touch them again, because the rules for both whether a contract is enforceable or if a privacy policy can be applied is that the user has to, if you change it, your user has to be notified. So you either have to email everybody who's registered in your site, which I'm sure this is familiar. You get these emails from Instagram or Facebook or eBay or whatever services you're using saying, hey, we've updated our terms. That's why they're telling you, not because they're trying to be, a good citizen, but because the contract, it doesn't apply unless they've notified you. So you can do it through an email, or you can do it through a pop-up, or you can try to draft it so you don't have to update it much, which is probably the goal when you're first getting these going.
Okay. So when somebody goes on your website, I've seen the link there that says, see our privacy policy.
Mhm.
Do they generally have to acknowledge that they've reviewed it, or does it just have to be made available to them?
Yeah, so this was actually a really complex and controversial issue, maybe in the 90s, with software. And basically, it's settled that as long as you click through, it's called a click-through agreement, click to agree, you've agreed. Now, the terms of use of privacy policy are also going to say, by coming to our website, this applies. And for the most part, that's been held to apply and be applicable to a user. So it's going to say that. Now, if you have something like registration or a purchase, or if they're submitting information to you in some way, it can be a good idea to have that extra, click to agree to our terms and maybe a link to them. So it all depends kind of how serious the interaction is, how much you're going to expect your users to assent to your terms.
Okay, so a lot of times when I go on a site, I'm not sure I'm really clicking on terms of use, but I might have to click on something that says that I understand the cookies are being collected.
Sure.
And I'm guessing that, maybe that's a back way of kind of getting an agreement to the terms of use, or
So
are those totally separate?
that's actually a really interesting thing. The click to accept cookies thing is mostly a function of compliance with European law. Um, and the idea that you have to have that on your website, I think in the US, it's not, in my opinion, it's not required in the United States, but a lot of businesses are choosing to do it anyway, to have that click to agree to cookies.
Right.
And so it's interesting to me how widespread it's become, because it's actually a
definitely.
creature of European law.
Right. Okay. So while you might see that, you might not see that same click box for the terms of use. Okay. So one thing you and I were talking about that I kind of want to make clear is that this privacy policy is not the same thing as a business associate agreement that we talk about under HIPAA. So there's some overlap because you're kind of letting people know what you're going to be doing with their information, right? That you're collecting on the website. But when we talk about a business associate agreement, we're talking about patient or PHI,
Yeah.
protected health information that's being collected by the practice and what they're doing with it. So, the website might collect information and might share it with a vendor that uses it maybe for following up with the patient or trying to set up an appointment or something like that. And we would agree that most likely that covered entity is going to have a business associate agreement with that vendor, right? But here we have a patient going on a site and providing its information, and it is not yet necessarily a patient of the practice. So the idea is that a covered entity has limitations on what it can do with protected health information that it has gathered and who it can share it with. And, we want to protect that through HIPAA. When somebody like me is going on a site that I've never been on before, and I'm putting in my name and my weight and what I'm looking for, what my health conditions are, etc., I'm not yet a patient of the practice. So there's an overlap, but this policy that you're talking about, this privacy policy, is not what they can use their HIPAA forms for. And I want to make that really clear. If people are thinking, oh, I already have, a business associate agreement, or I already have a HIPAA privacy policy. Those are not the same thing, correct?
Yeah, that's a great point.
Okay, so those are different things. So if you think you've already hired a lawyer to do all your HIPAA stuff for you, this is not the same thing.
Yes.
So have you seen cases, and can you give us an example of, where a practice doesn't have one of these terms of use in place? Is this something that they could be in trouble with? Can they get sued? Is it like more of a statutory issue? Like what happens if they don't do it?
Actually, the things that come to mind are actually more so mistakes with privacy policies than terms of use. I think the terms of use, the biggest risk I would think is if you are putting out written content that could be construed as medical advice, that you don't have a disclaimer either on your website or in your terms of use. The privacy policy in particular, you can see if you tell your users like you're never going to share their information with anyone and you're doing that, or you tell your users that, if you ask to have your information deleted, we'll delete it, but you don't actually do that. That's where I think you see the most risk and you see the most actual litigation regarding these types of agreements. And most often that privacy policy risk comes from just grabbing someone's and not tailoring it to what you're actually doing, and maybe not even knowing what's in there and making sure you're complying with your own policy.
All right, perfect. So if you're listening to this podcast, you have a website, you have a mobile app, you're doing some kind of telemedicine site, you're wanting to sell products to patients, whatever it is that you're doing out there in the world of healthcare, separate and apart from all the normal healthcare warnings that, I talk about all the time, this is a different kind of issue to be aware of. You're going to need a terms of use and a privacy policy, and you're going to need to talk to someone like Scott to help get that done. So if you've heard those words and didn't understand why you needed it, you don't have one, you've never had one, let's reduce your risk now by getting it done and taken care of. So Scott, any final words on this topic that you want to share?
Yeah, I would say, it's interesting that you're comparing these to the other standard protective documents that a healthcare provider would need. These are much less painful. These are not, you can get these in place pretty easily and usually set them and forget them unless you're making changes.
Okay, perfect. Well, you heard it. If you have questions, please reach out to Scott directly. And this is just one of those things where you've got to just take care of business, and it's worth it at the end of the day to avoid any kind of issue arising. So, all right. Well, thanks for joining me, Scott.
Thank you.
All right. Well, this has been the Health Law Hotspot. Thanks for joining us, and we'll see you next time. You can catch our other podcasts at ralaw.com. Thanks.
The Retzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Retzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Retzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.